Dear colleagues, despite the efforts of states and the public, accidental spills of oil and oil products still happen around the world. In Russia, the number of such accidents run into thousands per year. Moreover, a large spill of oil and oil products may cause irreparable damage to the environment and may also entail substantial costs for the party that caused the incident. Today, we will talk about accidental spills of oil and oil products and compare how liability of the party that caused an incident works in the USA and in Russia. In particular, we will discuss who is obliged to eliminate damage. Is liability of the party that caused an incident limited? Which public authorities may assert claims seeking to have damage to the environment compensated? And of course, we will touch on many other things. Let us consider this issue in more detail. We start with the legal framework. In the US, three main laws regulate the assessment and compensation of environmental damage. The first is the Comprehensive Environmental Response, Compensation and Liability Act of 1980. Then there is the Clean Water Act of 1972. While the main law we'll be talking about quite considerably today is the law about oil pollution, namely the Oil Pollution Act of 1990. This law was enacted in response to a notorious environmental disaster that occurred in 1989, when an oil tanker called the Exxon Valdez struck a reef on the southern coast of the US state of Alaska. The accident caused a crude oil spill of the tens of thousands of cubic meters, which polluted water bodies and the coastline. Four main purposes of the Oil Pollution Act can be singled out. The first is to create a uniform regime of liability for those responsible for such disasters. The second is to tighten such liability. The third is to provide public authorities with broad powers to prosecute parties responsible for incidents. The fourth purpose is to set up a special trust fund to finance the elimination of such spills. In Russia, there are two principal regulatory acts that regulate compensating harm to the environment. These are naturally the well-known law on protecting the environment of 2002 and the provision of the Russian Civil Code regarding obligations in relation to harm. A number of subordinate regulatory instruments, which we'll also of course discuss today, were adopted in furtherance of the above regulations. As regards general principles of liability being imposed, under the Oil Pollution Act, a person who has permitted an accidental spill of oil products, is responsible first for eliminating the spill, which includes containing and cleaning up the oil, and second, for compensating 6 categories of losses. What kind of losses are these? These are the losses resulting from the destruction of property, the loss of profit, including taxes, royalties and rental payments, by public authorities due to the above destruction or damage to property. Then, naturally, there are losses resulting from the deterioration of or inability to use natural resources, the loss of profit or reduced earnings resulting from harm caused to property or to natural resources, and, of course, the costs of providing additional public services during or after the response to a spill. And finally, the 6th category, and, of course, the most important one, from our perspective at least, is losses which result from harm inflicted on natural resources. Under the Oil Pollution Act, natural resources are defined rather broadly to include land, fish, wildlife, biota, air, water, groundwater, drinking water supplies and other similar resources, which fall under the jurisdiction of various public authorities in the USA. Under US legislation, a party that caused harm is liable regardless of whether it was at fault. Therefore, if an incident resulted from the party's willful misconduct, negligence or gross negligence, the party at fault will be held liable. Under Russian law, a party that caused harm is also almost always liable, regardless of whether it was at fault. This is primarily due to the fact that such incidents generally occur at facilities that are sources of increased hazard. These, for example, include an oil pipeline, an oil rig, or a tanker. To be released from liability, a party that caused harm must prove that either either the harm was due to a force majeure or that the source of the increased hazard had been withdrawn from such party's possession against its will or as a result of unlawful acts of third parties. At the same time, the party itself must have undertaken all possible measures and efforts to ensure that its property, for example, was properly protected, and nor did it allow any third parties to enter its territory. The US and Russian laws are similar in this regard. In the US, if there are several parties that caused harm, their liability will be joint and several. In other words, a claim for harm to be compensated may be asserted against any of those parties. This can be exemplified by a collision of two ships resulting in an accidental spill of oil or oil products. A party that caused harm and compensated the damage will have the right to approach other parties that caused harm in order to settle issues of compensation. In Russia, however, the rules regarding the liability of several parties that caused harm are more differentiated and flexible. For instance, if harm to the environment was caused by the interaction of several sources of an increased hazard, their owners will be jointly and severally liable. Thus, an example in this case would be the owner of an oil pipeline and the owner of the construction machinery, the operation of which has resulted in damage to the pipeline and caused the accidental spill. Joint and several liability will also apply if parties that cause harm acted together. Acting together may manifest itself in an accord, in coordination, and in aiming to attain a common intention. An example might be a client who commissions certain work, which inflicts harm on the environment, and a contractor who actually performed such work. If, however, several parties acted independently of each other, and the actions of each of them caused harm to the environment, then, according to the general rule, such parties will face proportional liability. If no share can be determined for each of the parties that caused harm, then they will be liable in equal proportions. Let us discuss the financing of the elimination of oil spills. The oil spill during the wreck of the Exxon Valdez tanker in 1989 clearly demonstrated that the US had no adequate resources to respond to such large-scale oil spills. In this regard, the Oil Pollution Act provided for a special Oil Spill Liability Trust Fund, or so-called National Pollution Fund, to be created. The fund was established specifically to finance the cleanup of spills. The fund is replenished using taxes that are levied on each barrel of oil which is imported and produced in the US. Originally, the tax was 5 cents per barrel. Subsequently, the tax grew and the trust fund grew accordingly. Moreover, the fund is also replenished with a certain portion of the sums paid to compensate damage to the environment. The maximum amount per case, which can be diverted from the fund, is $1 billion, of which a maximum of 500 million can be spent on compensated damage to the environment. With some exceptions, claims for the compensation of harm must be made against the party that caused such harm and its insurance company. Only then, 90 days after the claim has been asserted, may one have recourse to the fund. If, however, a competent authority or another person claiming compensation for damage applies to court and to the other party that caused harm at the same time, then it will be impossible to apply to the fund. There is no such trust fund in Russia to finance removing large-scale oil spills and mitigating their impacts. Moreover, under the law, such an obligation to fully eliminate damage lies with the party that caused harm. However, this is not always effective because a company has limited resources and an accidental spill may simply lead to such company's bankruptcy, meaning that no one will pay for the harm caused at the end of the day. Let us talk about the size of losses. The Oil Pollution Act in the US stipulates that certain rules of environmental response, assessment and restoration following oil spills must be adopted. Such rules were adopted in 1996 by the US National Oceanic and Atmospheric Administration. According to the rules, Harm means an observable or measurable adverse change in natural resource or the deterioration of the condition of a natural resource. In its guidelines on how the rules should be applied, the National Oceanic and Atmospheric Administration, in particular, clarifies that the deterioration of natural resources cannot be presumed, and the damage must be observable, it should be measurable and quantitative. For instance, to estimate harm from the death of fish, one may assess how the fish population or the fish biomass has decreased. Damage is assessed by competent authorities according to a special procedure, which, among other things, includes assessing costs on restoration, replacing, or acquiring the equivalent of the damaged natural resources. According to the general rule, the Oil Pollution Act limits the size of harm which the party that caused such harm must compensate, unless an exception is applied, depending on a specific incident, type of a vessel, or another facility where the accident occurred. Thus, for example, the general rule is that for offshore facilities, which include, among other things, oil rigs, the maximum amount of harm that can be recovered is 75 million. It is worth mentioning, however, that the amount of costs on removal, including the removal efforts themselves, is not limited. An important aspect is that the Oil Pollution Act stipulates 6 exceptions which override limitations liability. What are these 6 exceptions? They include gross negligence, willful misconduct, violation of an applicable federal law, and also, importantly, a failure to report an oil spill. In addition, such exceptions include avoiding reasonable cooperation or refusing assistance requested by a competent authority in connection with the oil spill. Finally, they include non-compliance with an order issued by a competent federal authority. These exceptions encourage the party that caused harm to behave in good faith, as no limitation of liability will apply in a situation where such party acts unlawfully. In Russia, however, there is no limit on the size of compensation for harm, and in particular terms, it can come to billions of dollars. This is due to the fact that our country does not have any source of funding, such as a trust fund, which would allow it to find resources to remedy and restore the environment beyond the established limitations of liability. As concerns assessing the amount of compensation for harm, Russia has special regulations and methodologies in place which establish the formula for assessing the amount of harm. For example, harm caused to water bodies is assessed in accordance with Order Number 87 of the Russian Ministry of Natural Resources and the Environment dated 13 April 2009. This formula includes various rates and coefficients. It is presumed that the amount of harm assessed in this manner, on the basis of such methodologies, should have a link to costs required to restore the condition of the disturbed environment. In practice, however, such methodologies are of an abstract nature. Consequently, there is no such link. It should be noted that an objective assessment of the extent of harm to nature requires not only environmental monitoring to understand the state of these resources prior to the spill, but also the involvement of competent specialists, environmental scientists, biologists, and economists to determine as accurately as possible what changes have occurred to natural resources due to the spill and how much money it needs to restore them. It seems that Russian authorities simply do not have such resources, and therefore our country takes a rather less sophisticated approach. As a matter of fact, the difference in approaches to how harm is compensated in the US and in Russia can be illustrated by the following example. In January 2009, due to severe weather conditions, the offshore supply vessel Monarch collided with the Granite Point oil rig in Cook Inlet off the coast of Alaska and sank. As a result of the accident, large quantities of diesel fuel, as well as lubricating oil, entered the water body, which, when added together, caused harm to the environment. Under the Oil Pollution Act, the owner of the vessel Monarch was the responsible party. At the moment of the accident, however, the vessel's owner's liability was limited to 800,000 unless the master of the vessel was found guilty of gross negligence. The insurance company spent almost $2,700,000 and applied to the oil spill liability trust fund, seeking to have its monetary funds compensated, which has been paid in excess of the established liability cap. The body that manages the fund twice rejected the claim on the grounds that the master of the vessel had demonstrated gross negligence and hence no limitation of liability should have been applied in that case. Consequently, the insurance company had to apply to court. The district court disagreed with the management of the trust fund and found the latter's conclusion not based on evidence. Thus, the district court ordered the fund to consider the insurance company's claims for payment for a third time. Subsequently, the fund partially upheld the claim. Generally speaking, it is impossible to think of such a court decision in Russia because our legislation is not familiar with limiting liability in a case of harm to the environment. Moreover, we simply do not have a fund that finances the restoration of the environment in the event of oil spills. Therefore, if such a situation were to occur at a Russian water body, the party that caused harm would be obliged to bear the costs to remedy it, as in the US. In addition, however, it would be obliged to pay the state an amount of compensation for harm that had been assessed by an abstract formula from methodology number 87, without any limitations. In theory, the law provides for a possibility to offset, against the amount of compensation, the costs that party which caused harm incurred while remedying such harm. In practice, however, it should be noted that the Federal Service for Supervision of Natural Resources almost always refuses such offsets. Subsequently, a court may also find that such costs are unrelated to eliminating the harm or are not supported by sufficient documentation. Alternatively, the court may refuse the deduction of such costs in connection with bad faith conduct by the party that caused harm. As an example, during a notorious spill of oil products in Norilsk, a subsidiary of NORNICKEL incurred about 12 billion rubles in costs to clean up the spill and restore the environment. The court, however, ordered the company to additionally pay more than 146 billion rubles to compensate harm and refused to set off the costs in their entirety by referring to the bad faith conduct of the party that caused the harm. According to the court, the company had for a long time been scrimping on the maintenance and repairs of its equipment. Let us now talk about competent authorities. In the US, a number of public authorities can be recipients of compensation. This depends on which public authority has jurisdiction over the natural resource damaged by the spill. For instance, during the explosion of the DeepWater Horizon oil drilling rig in the Gulf of Mexico in 2010, a number of public bodies and persons received compensation, namely the US Fish and Wildlife Service, the National Park Service, the Department of the Interior, as well as governance and various agencies of the states which were affected by the spill. These included such states as Alabama, Florida, Louisiana, Mississippi, and Texas. In Russia, with the exception of such ponds and flood pits, water bodies are federally owned. So, the plaintiff in such cases is always the Federal Service for Supervision of Natural Resources. There have also been cases where the Federal Fisheries Agency has filed lawsuits seeking compensation for damage inflicted on fisheries resources. Typically, these two agencies act separately and independently of each other, and they assert different claims. As regards the procedure for compensating harm, in the US, the procedure consists of 3 stages: pre-assessment, planning, and the restoration of natural resources. At the pre-assessment stage, the relevant competent authorities establish whether natural resources have been disturbed, whether the relevant violations have been rectified, and if not, whether any remedial efforts are practicable in order to restore the natural resource to its original condition, if natural resources have not been disturbed, or the violations have been eliminated, or if there are no measures available to restore the resources, the process is completed. Otherwise, the competent authorities will notify the party that caused the harm and will develop what is referred to as a plan for restoring the condition of natural resources. At this stage, the competent authorities decide what condition the natural resources were in before harm was caused to them and what condition they should be restored to. The draft plan for assessing the harm and restoring the natural resources is made available to the public for comments to be received. The final plan will be handed down to the party that caused the harm, which will have 90 days to familiarize itself with the plan and to submit its proposal and observations. The plan may include two options for how the condition of natural resources should be restored. Option 1. The party that caused harm implements the plan using its own resources under the supervision of the competent authorities, and in addition compensates the competent authorities' costs relating to the assessment of the harm and the supervision of the implementation of the restoration plan. Option 2. The party that caused the harm immediately pays to the state the whole amount, which covers all expenses, including restoration costs. In practice, a claim is more common seeking to have monetary funds paid to the competent authorities who implement the restoration plan using their own resources. If the party that caused harm disagrees with the restoration plan, the competent authorities will have two options. They either may file with the federal court a lawsuit against such party that is at fault, or may submit their request for compensation of harm to the trust fund. Unfortunately, though, no equivalent procedure exists in Russia. Nonetheless, Article 78 of the Law on Protecting the Environment states that harm can be compensated in kind by way of the party that caused such harm implementing the restoration project. However, in contrast with the US, Russian legislation does not stipulate any specific requirements for such project or for the procedure for developing it. Therefore, there are actually no cases of a party that caused harm restoring a damaged water body under such projects. Moreover, there is an important nuance in Russian budgetary legislation. The amounts of the compensation for harm are paid to the federal budget and are ring-fenced, meaning that relevant funds are to be spent only on environmental efforts and projects. There is still no link to the restoration of a specific water body. This means that an amount of compensation for harm to a body of water that has been recovered by the relevant state supervisory authority can be used, for example, to implement a federal project to eliminate landfills or abandoned industrial sites in other regions. Meanwhile, the water body affected by the spill may remain unrestored. Here is an example to the contrary from the US practice. After the unprecedented spill at the DeepWater Horizon oil drilling rig in the Gulf of Mexico in 2010, the company BP paid $8.5 billion as a compensation for harm, in addition to financing efforts involving cleaning up the spill worth over $2 billion. The grand-scale plan to restore the natural resources was developed in 2016 and is still being implemented. To sum up, it must be acknowledged that since US has historically experienced much larger spills of oil and oil products, the instruments of public regulation there are somewhat more diverse. Specifically, a limitation has been introduced on the liability of businesses for oil spills, which only applies if the party that caused harm acts in good faith. The US insurance market is more developed than the Russian market, allowing businesses to insure against such liability more effectively within the limits. There is a special fund for above-limit liability, which is financed out of taxes and partly out of the compensation for environmental damage. Restoration of water body is financed based on specific restoration projects, which are developed specifically for each oil spill. Moreover, any harm is always assessed in specific rather than in abstract terms, and is based on an estimation of the costs necessary to restore the environment to its original state. It is clear that today we have been able to highlight only the most fundamental and major differences between the approaches of the US and Russian legal systems to the regulation of compensating environmental harm. It will surely require more than an hour to talk in detail about each of the aspects. That is all for today, however. We will try to keep you updated on this absorbing topic. Thank you and goodbye for now.